Thank you, Mr. Speaker, and I want to thank my colleagues for being here today and being so interested in this issue. We hear the Liberals opposite saying they want this to leave the House immediately, but some of us don't have a lot of chance to speak to bills that are outside of our portfolio area. I'm not on the Defence Committee, so that's not a place where I'm going to be able to participate. So this actually is my sole chance to be able to participate in this debate, and I hope that colleagues opposite understand that we're not ragging the puck here or anything. We just want to give people an opportunity to speak to the issues. And these are important issues, Mr. Speaker. They come out of a number of different areas, and I want to talk a little bit later about the Victims' Bill of Rights and what it means and how much it's improved and changed Canadians' lives. And certainly that's been the foundation of what we're doing. What C-77 is about is trying to apply that Bill of Rights to the military as well. And my colleague who spoke previously had basically the same opening that I did. We didn't share notes or anything, but he was talking about imitation being the sincerest form of flattery. And it's actually interesting, on the things that this government has actually succeeded in, they've had to copy us. The things that they haven't copied us on have been pretty much a disaster. You think about electoral reform and things like that. Their own initiatives haven't gone anywhere, but the ones that we had done the work for, we've laid the foundation, done the groundwork on, they have had some success. And I guess I think of things apart from this bill, things like CETA, the trade agreement with Europe that was finished, pretty much handed to them, concluded, and then they almost messed that up. They took it back and started messing with some of the text. The next thing, the Europeans wanted to open that bill or that whole agreement up again, and the government had to fight and struggle to make sure that it was implemented the way that we had negotiated it. TPP, we're seeing the same thing in the House here, Mr. Speaker, where there's an agreement that's basically been handed to them finished. We're sitting here 2.5 years later. We still don't have this thing through the House, even though we're the ones who did the work on it. It's a good agreement, should be implemented as soon as possible. And then certainly we're seeing struggles that they've had around NAFTA, where they've insisted on taking an agreement that worked very well and coming so close to making a complete mess of it here that Canadians need to understand that basically we're just saved at the last minute by the fact that U.S. auto sector stepped in and said, we need to get this agreement done. You can't be serious that you're going to allow the president to put these auto tariffs on. And so I think finally our government realized we better quit playing games trying to make the president look bad and fooling around that way. Let's just get this agreement done. And we've got it. Interestingly enough, Mr. Speaker, as with so many other things, they really didn't gain anything with it. We barely held the ground that we've had in the past, and that seems to be the way that this government operates. That brings us back to C-77, and hopefully something that will be much easier for them to get through in the form that it's in right now. And we've heard a debate about it this afternoon that to this point, we will support the bill to go to second reading as soon as the debate is done in the House here or whatever. But the point of it is to align the military justice system of Canada with the Criminal Code of Canada. It's a good objective and one that's important. And as I said before, it centers around the former Bill of Rights that was passed in 2015 and taking that Bill of Rights and then enshrining it into the National Defence Act. And a lot of people have talked specifically about C-77 and what's included in it, but I'd like to just back up a step, if I can, and talk a bit about the Victims' Bill of Rights that was passed in 2015, which lays the foundation for the discussion that we're having today and for the bill that is being presented here today. So if people will allow me to do that, I would like to speak about this for a few minutes. And obviously the Victims' Bill of Rights created a clear set of rights for victims of crime across Canada. It required those rights to be considered during the trial processes that take place, and it provides basically 4 rights for victims in Canada. And those rights are the ideas of information, of protection for their rights, of participation in the system, and then some aspect of restitution. And obviously, some of this stuff really seems to be common sense, but perhaps isn't in the courts. It seems the Canadians would understand that every victim should have the right to request information, get information from the system that they need in terms of the system and the role that victims play in that, the services and programs that are available to them. They should be aware of the fact that they have a right to file complaints if their rights are being violated, and certainly we believe that is the case. In the investigations, the victims have the right to ask about the status and outcome of the investigations. They have the right to know where the location of the proceedings are taking place as well. They have the right to ask for information about any kind of reviews that are being done under Corrections Canada and the Conditional Release Act that's taking place. So we've actually had, for the last week, been talking about an issue in Western Canada. Actually, it's in my riding, where a young lady who, I guess I use that word very loosely, but participated in the kidnapping and the rape, the torture, and the murder, and then the burial of an 8-year-old girl, was obviously sentenced to 25 years in prison because she was convicted of first-degree murder. And then we find out about a week ago that she's been moved from maximum to a maximum medium security prison a couple of years ago. And then in the last few weeks, she's been moved from there to what is basically a minimum security prison. Now, I'm familiar with the Okomaochi Healing Lodge. It's in my riding. I've been there several times. I've been there for their open days and enjoyed being able to go there. But this is not the appropriate place for someone like that. And as I point out, the victims' rights require that those who have suffered under that have the opportunity to find out what's going on in the system. And certainly when her father, Tori Stafford's father, found out what had happened, he has appealed to the Prime Minister and said, look, this is crazy. This person had murdered my daughter. I have to live with that every day of my life, and you've sent her to a minimum security prison. Not only a prison that has no fence around it, it's in a treed area, it's like a park setting with these small cabins arranged in small units. But not only do they not have, it has no fence around it, it has no restrictions or whatever, and there are children present because the children are allowed to come in and spend time with their mothers. And I think, Mr. Speaker, my constituents have made it clear to me what their opinion on this is, and it would agree with our position over the last week that this issue needs to be reversed. The reason we know about it is because there's a Victims' Bill of Rights, and that Bill of Rights then is the foundation for the changes that are being suggested in C-77. Certainly the hearings that are open, victims are allowed to attend those. In terms of protection and security, people have the right to have their security considered. In the criminal justice system, they have the protection, or they have the right to protection from intimidation and retaliation. We've talked about that today with regards to C-77. They have the right to have their privacy considered, and the appropriate privacy, have their identity protected as well, and that they have the right to request any kind of help that they might need when they're appearing as a witness in proceedings. There's other things around participation. Victims have the right to give their views about decisions to be made by the appropriate authorities in the criminal justice system that affect their rights. So they have the right to speak up, and we think that that's an important right. And, Mr. Speaker, we're all familiar with victim impact statements and the role that they play now when you see these court cases that go ahead and that allows the victims to get up and say, look, this is how this person has impacted my life, this is how this activity has destroyed, for example, our families' lives as well. And the Victims' Bill of Rights also talked, Mr. Speaker, about restitution orders and the fact that each victim has the right to have the court consider making restitution for them against the offender. There's a number of other things in the Victims' Bill of Rights, but certainly that lays a foundation for us for C-77, and are really enshrining that Victims' Bill of Rights in the National Defence Act is what this bill is about. It also puts the statute of limitations on 6 months on summary hearing cases. We heard this morning about the various levels of discipline, how the defense minister, if we trust him this morning, is trying to make some changes that will speed up some of the lesser, or the discipline on lesser offenses. And we're hoping that what they're saying is actually true as well. So, Mr. Speaker, this is virtually a copy of something that was presented 3 years ago by our government towards the end, just before the election. I guess the good thing is, as I mentioned, the Liberals have taken this on and have decided that they're going to basically bring the bill forward much the same fashion and structure that it was before, and to introduce those changes. There are some differences. I think we've talked about these a little bit here today as well. And one of the main differences in this bill, and I think probably will be one of the main things that will be discussed at committee, is the addition of the Gladue decision into the National Defence Act. And for those people across the country who are not familiar with that, it's a court decision that was made that instructs the courts to take into consideration an Aboriginal person's background when they're sentencing. And so, on occasion, when that's applied, it may mean that the sentencing, either the sentencing itself or the sentencing process, will be different for that individual than it would be for other people who are non-Aboriginal. And so I guess there are, people are bringing up and have brought this up prior. Is that something that should be considered in the military or not? Is this appropriate that in the military, where everyone has to be subject to the same structures of discipline, where we're trying to bring about equality, trying to bring about equal participation, that someone would have a different sentencing structure or different level of punishment than other people would based on these kind of considerations. So we're just going to be, I'm sure, asking those questions and bringing forward those issues at committee as well. Now, our government made it a priority to stand up for victims. That's why we brought forward the Victims' Bill of Rights. That's also why you would see our Bill C-77 coming forward prior to the election in pretty much the form that it is right now as being presented by this government. But we know that the priority of government on this side of the House anyhow should be to protect the safety of its citizens, and it's a responsibility that we took very seriously. Putting the rights of victims back into the center of the criminal justice system was important to us. It's something that we spoke about many times, that we made the center of a number of different pieces of legislation. And that obviously guarantees that victims have the right, that they have a more effective voice in the system, and that they are treated with courtesy and compassion. I guess we're all familiar with situations in the past years where often victims seem to be harassed more than they were treated with compassion and respect when they came forward with the charges that they felt they needed to make. We were determined to try to reverse that trend and make sure that people were treated with respect, and at the same time keep our streets and our cities and communities safe for Canadians and all of their families. So that's why we took so many concrete steps to hold people accountable for their actions. We're glad to see that that's being extended to the military as well. Now, I think the question I need to ask, Mr. Speaker, is: are the Liberals really serious about the bill that's being put forward here? They say they want this to go to committee as soon as possible, and we hope that that's right. But in the past, what we've seen is they're far more interested in PR when it comes to these issues of criminal activity than they are in the content. And we see that in this Parliament as well. C-71, I think, is the firearms legislation. And we see a bill that came forward, and the government has made a declaration that they want to deal with the crimes that's wrapped around gangs, and they want to deal with the illegal use of firearms. They come forward with a bill that doesn't mention either of those things, but does create massive problems for legitimate firearms owners in this country. It's almost as if they've gone, look, what's the PR side of this? We can probably make an attack on legitimate firearms owners. We can convince the media in this country that that's a good thing. We don't actually have to do the hard work of trying to solve the gang situation, of trying to get these illegal guns off the street. And so C-71 would be an example of where they don't seem to be taking this issue of crime seriously. I hope they are in C-77 on this bill. Another issue we had, and when I asked the question of the minister this morning, I'm trusting that he answered this honestly, but in C-71, another issue we had was misusing stats, where they try to take an extreme stat and then they apply it and then say, well, this is the average, and now we're going to operate from, using this as a starting point for our statistics, when anybody who knows the statistics knows that it was such an exceptional, 2013 is the year that they're using, was such an exceptional year that it didn't really actually fit into the normal trend lines at all. It's there's lots of attack on the regular citizens, it seems, particularly in C-71, and not much that would actually defend or protect the regular victims of crime. So we brought forward a number of other bills, and we were in power. The Safe Streets and Communities Act was another one. The reform of the not criminally responsible legislation, which was needed for many years. We were happy to bring that forward as well. And then laws against sexual intimidation and sexual exploitation, rather, and cyber intimidation. It's good to see that these changes are coming forward. I know that there's been some changes made since 2016, even within the military, and the government themselves talk about the fact that the Director of Military Prosecutions has changed the way that they actually do things, the way they approach these issues. And there's a number of things that in the government's documents they talk about how they have already introduced changes. And those kinds of things are things like they're now providing information proactively to victims on the choice of a jurisdiction, so in a sexual misconduct matter. So if there's a charge of sexual misconduct, the victim now has more say in what jurisdiction do you want to take a look at this, and we've got some information here we can provide you that will help you. Victims are kept informed throughout the investigation and throughout the trial process. That's something that wasn't happening before the way that it should have in the military, and the DMP has has, in their overhaul of the way that they've done things, included this as one of the things that they think is important. Now they've started to consider the views of the victim in determining the public interest in these cases. So is there a public interest in moving forward with the prosecution of these cases? And they're allowing the victims to have some participation in that. I know that witness preparation has been improved. They're spending more time with witnesses, sitting down with them and saying, look, if you're going to be testifying, what is it that you're testifying to, and are you prepared to be a competent witness here? Assuring victim comfort and security, I'm told, is one of the key considerations. And in the past, again, as I mentioned, people have been intimidated, even by the way the system is set up, and so this is set up to be much more fair to them. They are making efforts to make sure that in sexual misconduct cases that victim impact statements are relevant and are considered as well, and that they are trying to get consistency with the prosecution and the prosecutors so that each of them is approaching the issues in the same way. And I think, Mr. Speaker, that's probably an important consideration in this issue, that there needs to be a consistency within the military itself in the way that they deal and address these issues. And that is part of what C-77 is trying to do, is to bring the consistency that's provided from the Victims' Bill of Rights into the military part of this justice system. And then another thing, I guess, Mr. Speaker, that the sexual misconduct cases are actually being expedited in the military courts to try to get them out of the way. So there's a lot of things going on here. I mentioned the Indigenous sentencing considerations. We heard earlier today that there are changes to the summary trial process and the way these summary charges are handled. A number of other areas around the victims' rights at court-martials as well that have changed, that they have a different perspective, a different opportunity. And there's a victims liaison officer that will be put in place in order to give victims an opportunity to get this information and go to somebody who can actually work with them and help them. So, Mr. Speaker, again, we come back to, I guess, a concern that they are actually honest about dealing with victims. I know my time's almost running out here, but we've seen over the last 3 or 4 weeks in the House of Commons here a gentleman who murdered a police officer, female police officer, desecrated the body, sentenced to jail, and then he applies for Veterans Affairs benefits, and the government here has been providing those benefits for him. Those are benefits that I'm told can be provided by correctional services, but the government's made the decision that he deserves veterans benefits. And we've argued, no, he doesn't. There are people who have actually served. He has not served, and it's been a moment of time in our military service, and yet he's getting these benefits. Now, finally, the government said, well, we'll cut them off for now, but we need a better response than that from the government. And that was a bad response on that case. We see now with Tory Stafford and the comments that the Minister of Public Security made this afternoon, another slow response, another bad response to people who have been victimized in the worst ways by crimes. And the best that the ministers of this government can say is, well, you know what? We've given it to somebody and they're going to review it for a long time, and when they get back to here, we'll let you know how that's going to turn out. Well, in this case of Tory Stafford, by the time that happens, how long will that woman have been in the Okama-Ochi Healing Lodge, being able to do whatever she wants to do in terms of having access to children and having access to just wandering off the property if she wants. She's not eligible for parole for another 13 years. What does she have to lose should she decide to do something inappropriate in Okama-Ochi? So that's just an example. This government is not willing to react to these issues. We hope on this bill that when it comes to committee that they're going to deal seriously with it, that when it moves forward from there, that when it's implemented, that they actually will treat it seriously, because they don't have a history of anywhere else of actually dealing fairly and honestly with victims. Hopefully in this situation we're going to find that they will, and we look forward to seeing when this bill is applied. It's a good bill. We wrote most of it. We're looking forward to the government applying it, and hopefully it will take care of many of these issues that people have faced around military trials and those kinds of situations. Thank you.
Questions and comments. The honourable member for Pierrefonds-Dollard.
Thank you, Mr. Speaker. There's a couple of points that the members brought up that I fully agree with. Number one, he said that it's important to have a debate on victims' rights, and I concur with him on that. He's also made the point that this bill really builds on a previous bill by the previous government, Bill C-71, which did not make it through debate, but it takes a number of those points on victims' rights and puts them into this new bill. I think about the rights for privacy and security for victims of special types of heinous crimes, such as sexual crimes. I think about the ban on publication for our minors, people under 18, and I fully agree with all that. He's also brought up the point that this bill adds a couple of new positions, things to consider, specifically sentencing when it comes to Aboriginals and gender identity. And I'd like to hear his thoughts with respect to, does he see the opportunity to expand on that? And if so, how would he like to see us address specifically Aboriginals and gender identity?
Honourable member for Cypress Hills Grasslands.
Well, I think this had been addressed earlier today in terms of the notion of military culture. What is it that you want in your military when people are training together? They're all under basically one system, one structure. They're expected to adhere to that. It's a command structure. Do you want various interpretations of that? Do you want everybody to be working together to the same ends? And I guess that's a discussion that the committee is going to have about how many kind of variations of military discipline and structure do you want in the military in order for them to structure properly or to function properly. And in this case, it is the application of the military criminal code to people who are facing sentencing. Do you want different applications of it? Do you want the same application? That's something the committee is going to have to take a look at, have a good discussion about, and I think we'll probably make some recommendations on that issue.
Questions and comments? The honourable member for Renfrew, Nipissing, Pembroke.
Thank you, Mr. Speaker. Now, the member spoke about consequences of the Gladue decision. Could he tell us any challenges he sees in terms of applying that and having the similar provisions provided in theatre as would be in Canada for this decision and the consequences thereof?
The honourable member for Cypress Hills Grasslands.
Well, I think obviously this bill covers a fair amount of territory in a number of areas or whatever, but in this situation it seems, again, it comes back to, do we want different structures applied to different people? Do you want the similar structures applied across the board within the military? What is it that the government and the Canadian military need to have in order for the military to be able to operate fairly with its members and yet directly and be effective? We spent years on the Victims' Bill of Rights, spent years actually and talking to hundreds of submissions, talking to people across this country about what is it that we need to put in place in order to put a decent Victims' Bill of Rights in place, and it seems to have struck the balance it needed to be. Now those provisions are being applied to this bill, being put into place in this bill, and it seems like, as far as I can tell, most of those things would actually apply very well at the military level as well. And so it's good that we're talking about getting this to committee as soon as possible. I think everybody would like to see that, and that's where that discussion will take place. If there's amendments, there are opportunity, of course, for amendments at committee. There's opportunity for amendments once it gets to Senate, or the other place as well, and they have the debate on this bill as well.
Question questions and comments? The Honourable Parliamentary Secretary to the Government House Leader.
So thank you, Mr. Speaker. And I think the legislation is something that individuals, both inside and outside of the House, would recognize as fairly good, solid legislation. A good portion of it was something that was presented a few years back when Stephen Harper was the Prime Minister. There are some additions to it. There was a great deal more of consultation, for example, with Indigenous people. That's been factored in. We need to reflect on the fact that you have civilian law and you have military justice. And it puts them closer together, in essence, in terms of that Indigenous factor, if I can put it in that fashion. And I see that as a positive thing. But the question I have for my colleague across the way is that it seems to me that all parties in this chamber are anxious to see the bill ultimately go to committee. We all support the bill going to committee. I'm wondering if the member across the way would agree that maybe it is time that we allow the bill to go to committee so that we can have that discussion that he's talking about in terms of that Indigenous component that's in the civilian, that's being incorporated into the military justice and some of the concerns that the Conservatives might have in regards to that.
Member for Cypress Hills Grasslands.
I find it interesting, Mr. Speaker, that our discussion actually has veered off of victims again back to offenders, right? how do we treat offenders? Do we treat different offenders differently or whatever? But we're talking about a victim's bill of rights that's being applied to the military. And so once again, as soon as we start talking about victims, the Liberals seem to go, okay, we've got to talk about offenders here and giving some special breaks to people of some sort in order to, so we don't have to treat crimes seriously. And it doesn't just happen in this bill. It's a kind of a way of thinking, I think, on their side of the House, that every time we turn around, every bill that comes through here, there's some kind of expectation that we're going to, or their expectation is that we're going to be concerned first about offenders, and then we'll begin to consider the situation that victims find themselves in. And thankfully, this bill is not that. It's a different, has a different direction to it. And as again, I'll point out that it does a number of things. It's going to enhance access to information. And so I mentioned the liaison officer, the victim liaison officer before. That's a good thing. There'll be an appointment of an officer so people will be able to get extended and enhanced access to information. There's enhanced protection for victims, not for offenders in this bill, but for victims. There's new safety, there's no security provisions, there's new privacy provisions in this bill that will be applied. There's enhanced participation for victims. Again, not for offenders to come and say, you know, let us off here. This is supposed to be for victims, allowing them to give impact statements at their sentencing, so that, again, the offenders are held accountable for what they've done, not finding ways to let them off and lessen those sentences. And then the fourth thing we talked about a little bit earlier was that enhanced restitution, the possibilities of restitution that exist in the legislation. Court martials can be required to consider making restitution in order for losses suffered by victims. So I want to refocus this back to the fact that this is a bill about dealing with victims, giving the victims better standing and a better status and a better opportunity to have their say than it is about offenders and how we might find other ways and multiple ways of letting offenders off and letting them have easier sentences and letting them not pay the price for the offenses that they've done.
Questions and comments? The honourable member for Kingston and the Islands.
Thank you much, Mr. Speaker. The member started off answering the last question talking about veering off, and all he did was veer off from answering the question that he was asked. He was asked a question about, we've been talking about this a lot. This came up a few years ago, and it was talked about a lot then. Now's the time to move this on to committee so that it can be properly studied there. So the question is for the member, is he interested in seeing this move on, and can we get to that stage now? He said earlier on that he thought it was extremely important for everybody to say their piece and to be contributing, and I couldn't agree more. The only problem is everything we keep hearing from the other side is the exact same talking points over and over and over. There's no new contribution to the debate. So my question is, if we've heard it all and it's been repeated over and over, can we now send it on to committee, and will he support that?
Good question.
The honourable member for Cypress Hills Grasslands.
Well, I should point out something else that I pointed out at the beginning of my speech, is that this is the only opportunity that I've had to speak to this, and there are others in that same boat. Are not on the Defence Committee. I don't know if the member opposite is on the Defence Committee or not, but if he is, he is. Okay, so he has the opportunity to speak here. He's going to have the opportunity to sit in Defence Committee with the hearings, with witnesses. Those are all great in that, but the rest of us don't necessarily get those same opportunities. And so I'm thankful to be able to come here. I'm sorry that he's sat here long enough that he seems to think that he's hearing the same things again and again. But I believe we touched on some relevant things that not everyone else has spoken about this afternoon. And I think that last point that I made about focusing on victims instead of finding ways to let offenders off in some various ways is something that I think we need to come back to again and again with this government and remind them. Some people pay the price for other people's bad behaviour.
Comments? The honourable member for Selkirk, Interlake, Eastman.
Well, thank you, Mr. Speaker, and I want to thank my friend from Cypress Grasslands for his enlightening speech today. And I can tell you that someone that has been around here for over 20 years, he understands the importance of debate and the opportunity to talk about the issues at hand. And for members of the government to say that, you know, we're talking about things that they've already heard and they don't want to listen to debate anymore. Well, you know, that type of arrogance is what gets democracy in trouble. What we want is making sure that every member that wants to be able to articulate themselves on a particular item, in this case, Bill C-77, have that opportunity, especially when they have constituents who are interested in this very topic. And it doesn't matter if you're interested in national defense or if you're interested in victims' rights, you have to be able to stand in this place and share that view so that people can actually be informed when we have the votes. That's what informed debate is all about. And so I just want to thank the member from Cypress Hills Grasslands for his great articulation today of the issue and for his passion to stand up for victims' rights.
Member for Cypress Hills Grasslands.
Thank you, Mr. Speaker. And actually, you know, this is not theoretical. We come back to a bill, it's the C-75, I think, right? It was the reduction of the sentences bill. We've got 26 various criminal offences that this government has brought forward a bill, and they want to reduce those from being indictable offences down to summary convictions, so that people who belong to terrorist organizations, I think is one of them, gang membership, there's a whole host, 26 different things where they're saying, look, we need to reduce the sentences. He'd probably say the same thing. We've talked about this too much. Let's just go on with it. Canadians need to hear these things, and they need to understand the commitment that this Liberal government has to watering down any kind of protection that victims have in this country. We need to keep saying that again and again until it soaks into their thick skulls that they need to start figuring out some way that they can actually step up forward and protect victims instead of always taking the side of the offender against those people who have paid the price for those other people's bad and illegal behavior.